Good evening, everyone. Welcome to today's webinar on managing construction disputes in Oman, brought to you by MRP Advisory. I'm Roshanara Rauf, Principal Associate at MRP Advisory, and I'll be your moderator for this session. We're delighted to have with us a distinguished panel of experts from legal and consultancy backgrounds who will share their insights on the key challenges, evolving trends, and practical strategies in managing construction disputes in Oman. Our panel includes Mr. Abdulredha Lawati, founder of ALC Lawyers and Counsels, Mr. David Johnson, barrister at Atkin Chambers, Mr. Nikolay Khomyak, Associate Director at SW Tenet, and Mr. Adarsh Ramakrishnan, Partner at MRP Advisory. The format for today's session is a rotating Q&A. Each panelist will be asked one question at a time. We'll also aim to take a few audience questions at the end, subject to time. Let's get started. Let's begin with the legal framework. Mr. Redha, what are the key features of Oman's legal framework governing construction disputes, particularly in relation to arbitration?
Thank you very much for this introduction, Roshanara. And it would be very nice to speak with you all and share the thoughts and discussion with my colleagues on the panel. So basically talking about the arbitration field in Oman, we have a wide arbitration practice in Oman covering the construction disputes overall, taking into consideration that the Omani arbitration law is limited to civil and commercial deals and transactions, basically. So we would confirm that the construction disputes is one of the key areas that could be covered by the arbitration practice overall, and always regulated by the Omani arbitration law locally. If we talk about the framework briefly, because talking about the details, it won't be enough for even half day. But briefly talking about the arbitration disputes in construction sector, that means that we are always deal with contracts first of all, because an arbitration dispute is the alternative way to solve the dispute under the civil law principles. Mainly, it means that the parties have agreed to seek the arbitration for any dispute settlement between the contractor and the employer. If we jump a little bit deeper into the laws, exactly, we are having always two types of laws that we have to deal with. We have the procedural law and we have the substantial law. Mainly the formal law or the procedural law is the law which regulates the procedure of the dispute settlement, whether it's arbitration or court. But we assume that the arbitration is already covered by the arbitration law, and in a very narrow areas we are having the civil and commercial procedural law in Oman, covering the procedural part of the dispute. Talking about the substantive law, basically we are talking about too many substantial laws, assuming that the disputant parties are juristic, so we are involving more laws to be covered in the substantive law, but mainly the civil transaction law after the agreement will be covered in the dispute. So we have the agreement in the substantive part, we have the civil transaction law, we have the commercial companies law. If there are other areas to be discussed in the dispute, then such as engineering, the engineering consultancy laws, we have the insurance laws, because we are talking about construction sector. So the construction sector is quite wide and covers more substantial part. The Omani arbitration law basically is based on a standard law which is promulgated in 1997. It was uh, one of the oldest GCC laws in the GCC area. I think Saudi Arabia started first, promulgated firstly the arbitration practice, then Oman in 1997 promulgated the Omani arbitration law. And this, by the way, this law was promulgated even before the date of promulgation of civil, commercial and civil procedure law, which means that Oman has ratified the arbitration practice even before the courts get regulated procedurally. Mainly, if we go a little bit deeper into the arbitration law, we will find that the Omani arbitration law has even given the parties mainly to choose their substantive law, to choose their procedural law, to choose their arbitrators, to choose the jurisdiction, the seat of the arbitration. So there are lots of flexibility that were provided in the arbitration law to help the parties to solve their disputes as an alternative dispute settlement way, and therefore we can find also that when after that when the civil and commercial procedure law was promulgated, we found that even the law has covered the gaps which were found in the arbitration law later on, such as enforcement of foreign awards, including the foreign arbitral awards mainly. When we go through the substantive part, there is a common civil principle in the law which clearly states that the contract should be the law of the parties in the beginning, which means that the law that the agreement which was executed between the parties shall be binding in the dispute. Whatever gaps could be always covered by the civil transaction law. What I understand mainly that there are lots of contracts were issued before 2013, but after 2013 there was a civil transaction law covering any practice or let's say principles that should be adopted by the parties in the construction field. So this is brief about the regulation, or let's say the legal framework that is governing overall the construction disputes so far. And I think we have also the court precedents which got developed by time, especially after the promulgation of the civil transaction law, that could be also relied on from time to time to be followed or to be at least highlighted in the disputes overall.
Thank you, Mr. Redha. That was insightful. Adarsh, looking at the current environment, what are the recent trends in the types of disputes arising in construction projects in Oman, especially post-COVID and considering Oman's Vision 2040 strategy?
Thank you so much for that question, Roshanara, and thank you everyone for joining this webinar. I must really admire Oman's route on how they have adopted their Vision 2040 plan. It is pretty different from the style and nature of the other GCC nations who have adopted other vision plans that they have outlined for the next decade. First of all, the Vision 2040 is essentially a repackaged and expanded version of the earlier Vision 2020 plan. And it seeks to include several ambitious projects. And I just thought we should just revisit some of them because they are really fascinating. Because some of them are in the nature of urban and mixed-use developments like the new Sultan Haitham city, which is being constructed right next to the capital city of Muscat. And it's going to be a smart city project with several phases. They're not building skyscrapers like other GCC cities who seem to be engaged in a race to build really tall skyscrapers. Then there's going to be a new downtown and waterfront development, which is going to feature a marina and cultural zones. Then there is also going to be several very interesting infrastructure and transport projects that are undergoing. We know that the India, Middle East, Europe, East-West corridor is going to create a lot of rail connectivity, especially connecting to the from the east side, eastern ports to UAE and beyond. So, and then of course there are electricity distribution projects, ports, the very famous Dukum refinery projects, which includes much more than just a refinery. And of course, some very interesting airports that are being constructed to expand the aviation network within Oman. So all of these projects are taking place simultaneously, and all of them require careful design management to ensure that there are no problems later. So design, and the second aspect is of course financing. So if you're able to figure out the correct scope of work, and if you're able to figure out the precise budget, allowing for some overrun, most of these projects are going to bloom into some beautiful and exciting projects in the region. So, what are the problems that can potentially happen apart from design and finance? We know some of these are already encountering problems in the sense of negotiations in relation to supply chain issues, global inflation, and other geopolitical issues. So there is an increased scrutiny, but Oman is not lying idle. They have a vision unit set out to make sure that the Vision 2040 is mapped out and being executed properly. They have an implementation follow-up unit, which is going to monitor the progress. And there's a lot of to make sure that there are no project management failures. And all of these are being managed very impressively. So, whereas in the beginning, in the first 5 years, there was an influx of project finance and project finance lawyers. Now, there is slowly demand for dispute resolution lawyers who are looking at how these projects are being implemented. So, I expect in terms of recent trends, a lot of disputes in relation to price escalation, a lot of disputes in relation to scope and work overrun. A lot of them are bubbling under the surface, especially in relation to subcontract and supply chain issues. But eventually, they're also going to affect the main contracts, which is where the likes of lawyers and experts are likely to step in. Thank you.
Thank you, Adarsh. Now let's turn to how courts view time bar provisions, a vital aspect for contractors trying to preserve their claims. David, how do Omani courts interpret contractual time bar provisions in light of the civil court's principles of good faith? What best practices should contractors adopt to protect their entitlements?
Thank you, Roshanara, for the question. Thank you, everyone, for joining us, and to MRP for hosting what has so far already been an interesting discussion. Before addressing the specific point about time bar provisions, it's necessary perhaps just to follow on from Mr. Redda's very helpful summary of the sources of Omani law to understand where the obligation of good faith sits within the Omani legal system. And like many legal systems, Omani law is made up of a number of juridical sources, some of which are written, some of which are unwritten. But it's based heavily on a civil law system that like many GCC countries, borrows from principles of Islamic Sharia, as well as in Oman's case, originally Egyptian and prior to that French legal traditions, which are all find their influence in what is the present day Omani law. And like many legal systems, there are a number of statutes, royal decrees, and subsequently decisions of the court. But what we're particularly interested in here is Royal Decree 29 of 2013, which for civil matters is one of the most important in Omani law. It's what's referred to as the Omani Civil Code, and it sets out a comprehensive number of provisions which deal with all manner of civil and commercial matters principally, and is one of the primary sources for legal principles in Omani law. And within the Omani Civil Code, there are some provisions that I think before we discuss good faith, it's perhaps important to note. Article 155 of the Omani Civil Code provides that where parties have entered into a contract, that contract is the law of the parties, and save in limited circumstances, that contract prevails over all else. And Article 156 provides that a contract must be performed in accordance with its contents. The contract shall not be restricted to binding the contracting parties to the contents of the contract, but shall also embrace whatever is necessary to perform such obligations according to the law, custom, and justice, and as necessitated by the nature of the disposition. And these provisions, this draws on what's often referred to by the Latin maxim of pacta sunt servanda, which is essentially agreements must be kept. In other words, parties are expected to perform contractual agreements in accordance with their provisions. And it's an important touchstone in Omani law, just as it is in many other legal systems across the world. And finally, in this context, Article 165 of the Civil Code provides that if the wording of a contract is clear, it may not be departed from under the pretext of construing the same to find the intention of the parties. If there is ambiguity in the phrase of the contract, it must be construed to find the mutual intention of the parties without limiting the construction. This should be guided by the nature of the transaction, the common practices, and trust and confidence which should exist between parties to a contract. So the starting point, just like in many other legal systems, is that parties will be held to the strict wording of their contracts. Now, as with many legal systems, particularly those in the GCC, there are ways in which that can be mitigated. One of which is the principle of good faith, which is common to all jurisdictions in the GCC. But it's perhaps worth picking up on one point, which is that unlike many of the other GCC civil codes, the Omani Civil Code does not actually have any statutory definition of good faith. It doesn't seek to actually define the requirements of good faith, nor does it actually stipulate anywhere that a contract must be performed in accordance with good faith. Instead, it's a little more fragmented. The reference to good faith is found in a number of different provisions within the Civil Code. It's been referred to quite extensively by the Omani courts. A very well-known decision of the Supreme Court in February 2006, where the court ruled that that contracts shall be executed according to their provisions and in a manner that corresponds to good faith. So one way or another, there's no dispute that contracts in Oman and governed by Omani law are subject to the principle of good faith. And notwithstanding the lack of any definition, it's generally accepted by jurists and by lawyers alike that good faith as a minimum includes some sort of honesty in one's dealings in a contract, faithfulness to obligations, upholding standards of commercial fair dealing, and absence of unconscionability or perhaps sharp practice, and ultimately translates to a positive obligation not to use the contract terms to try to put the other party into a disadvantageous position or to abuse their position or so on and so forth. Now, as with many other jurisdictions, this obligation of good faith is frequently invoked by parties who might seek to avoid the application or mitigate the application of potentially onerous contract terms. And nowhere really is this more prevalent or more obvious than when one is dealing with time bar provisions in contracts. For example, where one is required to serve a notice within a set period of time, and particularly so in contracts where the obligation is expressed in such a way that the service of a notice is what's known in legal terms as a condition precedent. Namely, in other words, if you don't comply with the notice provision, you may be barred from ultimately claiming your entitlement, whether that be an entitlement to a variation, to an extension of time, to loss and expense, and so on. And many, in fact, almost all standard form contracts contain these notice and time bar provisions in one form or another. The FIDIC suite of contracts, which is commonly known, I'm sure, to many of the people on attending this event, is one of the ones that is actually more onerous than some, because it contains not only clear stipulations as to the period of time within which various notices are to be served, but also spells out the consequences in many cases of failing to do so, and makes clear that by the wording of the contract itself, the failure to serve a notice can, in fact, bar a party from being entitled to claim as a result. And in English law, for example, which is prepared to construe a contract quite literally, there have been many instances where a party has been precluded from claiming their entitlement to whatever claim it was they're seeking as a result of a failure to comply with notice and time bar provisions like that. Now, by contrast, in Oman, the Omani courts and tribunals have demonstrated perhaps slightly more of a willingness to set aside or to relax those time bar provisions, and have frequently done so on the basis of the application of the principle of good faith. They don't do it as a blanket approach, but there are specific permutations or specific sort of features, if you like, that might lead a court or tribunal to do so. For example, in circumstances where the time bar provision is quite onerous, where you have a very short period of time within which to serve your notice, the courts have previously held that a party should be excused from a failure to comply with that. Where, for example, the employer's own conduct, or indeed the main contractor, if it's a subcontractor dispute, was itself responsible for the events giving rise to the claim, the courts have and tribunals have been prepared to acknowledge that a party who is themselves in breach or where their conduct has given rise to the claim, they should not be permitted to rely on a time bar to avoid the claim. And similarly, if the claim appears in substance to be a good one and ultimately is a considerable entitlement, then the Omani courts have been prepared to recognise it, notwithstanding the failure to comply with certain time bar provisions. But what is particularly important to draw together from those two sides of the coin is that it's not a carte blanche. It is not an open invitation by Omani courts or tribunals to fail to comply with time bar provisions and then subsequently to bring your claim. You must show an attempt to have tried to comply, or at least some very clear mitigating factor as to why the breach, which is ultimately what it will be of a contract provision, is to be excused. And I think in this regard, again, one can draw on the various factors that the courts have held relevant in the past. If one of the things that has been key in Omani law, just as it is in many legal systems, is to identify whether or not there's been any prejudice to the recipient of the notice as a result of the failure to serve one. And that's true in Omani law, just as it is in many other legal systems. If you can show as the contractor or indeed the subcontractor that you have, even if you've not complied with the strict notification provisions in a contract, you have done your best to provide some sort of informal notice, some sort of informal update as time goes along as to the delaying effects, it will be much harder for the party seeking to deny entitlement to rely on the notice provision to rely on that provision ultimately. And whilst not determinative, I think that is probably for me one of the key elements where one is seeking to get around the failure to comply. So I think what this means, that as ever, it means doing the hard work first. It means making sure that as the project is ongoing, one has to not only be very aware of what time bar provisions are in your contract, but also to make sure that you are dedicated to tracking any potential claims much earlier than when they actually might transpire into full claims, be it for an extension of time, be it financial claims, and consider serving protective notices, whether informally or formally. Make sure you document the events as best you can at the time, and then that way it's much more difficult for an employer later on to seek to invoke a notice provision and to deny the contractor's entitlement. So, I mean, as ever, unfortunately, whenever good faith comes into play, one sacrifices predictability and certainty. And I think one can't expect in Omani law either that a notice provision will be upheld or won't be. But I think there are plenty of things that a contractor can do or a subcontractor can do to increase their chances of a tribunal or a court accepting their claim, even if they haven't complied to the letter with those provisions. Thank you.
Thank you, David. We'll now shift from legal interpretation to practical dispute management, particularly around evidence. Nikolay, turning to evidentiary matters, what are best practices when managing expert witness evidence, particularly quantum and delay experts in the Omani context?
Yeah. Good afternoon, everyone. Thank you so much. It's a big pleasure being here. Thank you, my colleagues. And thank you for the very interesting question. So managing expert witness evidence effectively is critical and very crucial in Omani construction arbitrations, particularly for quantum and delay experts. This is because of complicated, technical, and often continuous nature of such disputes. So in my opinion, here are some key best practices. So first one would be clear, objective, and methodologically sound reports. So experts should ground their analysis in recognized methodologies. So let's start, for example, with delay analysis. There are some well-known technologies like SCL delay protocol or double CEI guidelines, including forensic schedule analysis, time impact analysis, forensic cost analysis, and others. So these documents are widely used as a best practice standard in construction dispute. They establish a structured framework how to analyze delays, and they help experts, lawyers, and tribunals assess delays, like delay-related claims, fairly and clearly. And their key advantage that they are fair, neutral, and transparent. So they establish clear rules how to analyze delays and propose such methods as time impact analysis, as planned as built methods, collapsed as built, impact as planned, and retrospective and others. They establish clear definition what delays are. So what are critical delays, what are non-critical delays, concurrent delays, compensable, excusable, and so on. Speaking of quantum reports, here are some well-recognized methodologies as well. For example, ICC cost principles, RICS guidance, quantum of damages, double ACE international forensic cost analysis, and many others. And they establish also clear methods how to calculate damages, and they use such methods as actual cost method, market price, comparative methods, cost-based method, time-based method, and so on. The next thing I would say that beside methodologies, you should align expert reports with Omani legal standards if we speak about Oman. So local practices such as reliance in Oman's civil code that David has mentioned also for contractual interpretation should also be addressed fully. And probably I would say that we need to ensure we need to ensure reports comply with Omani procedures rules, like for example with Omani arbitration law or institutional rules like Oman Commercial Arbitration Center or any others if we speak about other jurisdictions like ICC, DIAC, and others. The second thing I would say about best practices is clarity and independence. So quantum and delay reports must be clear, concise, and free from advocacy. So Omani tribunal, they value objectivity, so experts should have a voice over reach and focus on factual analysis. Also, the third thing would be, I would say, cultural and practical considerations. So amongst legal culture, values detailed documentation. So experts should meticulously reference project reports like schedules, protocols, minutes, diaries, approvals, whatever, to counter allegations of speculative opinions. The next thing would be effective use of joint reports, I would say, because where possible, encourage joint expert meetings to narrow issues. It's good because they aligns with Oman's growing interest and emphasis on efficiency. They like when two well-known experts sit together. They just share their expert opinion on some precise matter, and they just give a joint opinion, and that's great. That's because you can be sure that this opinion is good, is correct, is concise. And the last thing I would like to mention is cross-examination preparedness. So you need to anticipate challenges to methodologies you use and prepare expert to defend their assumptions under scrutiny. And for quantum experts, you need to be ready to justify cost allocations under Omani contract law principles. Like we all know that cross-examination is a major part of your success in arbitration, so we need to be prepared. So in summary, success hinges adherence to contractual standards, methodologies, clarity, independence, and tailoring evidence to Oman procedural and cultural context, I would say. So a well-managed expert process can significantly enhance the tribunal's understanding and the party's position. So I reckon it's more or less are the key things to bear in mind regarding managing expert witness evidence in construction arbitration. So thank you so much.
Thank you, Nikolay. Mr. Rida, Oman, like many MENA jurisdictions, imposes a strict form of decennial liability on contractors and designers, which is joint and several in nature and cannot be contractually excluded. Given its mandatory character, how should contractors and consultants operating in Oman manage their risk and insurance strategies, and what are the key legal considerations parties should be aware of when negotiating construction contracts under this framework?
So mainly the 10 years condition in the law is obtained, the 10 years condition, which is the assumed confirmation liability, period of liability that could be always undertaken by the contractors and engineers are, from my own perspective, I would say that this period exactly could be the assumed maximum period that is set out by the law mainly. I think this article mainly was designed to be the most difficult article for all the contractors and engineers providing their services to the employer. However, I'm still in belief that this period, this time, or this 10 years liability could be always agreed on with lower period. I have come across a few years back in some disputes where the main liability, the maximum years of liability imposed on the contractor was around 8 years or 7 years, and the court has accepted that, which is a clear indication showing that the law has assumed something, but still the parties can always, agree on something. And as David has mentioned, the parties always should act in good faith. But I am adding also that the court goes beyond that. It goes to the intention. It's all about the interpretation of the intentions under the civil law principle. So I have to clarify this, that the 10 years is the maximum time liability, but still the parties can go before lower than this period as per their contracts. Now, going to the second part of your question, basically the management of the risks or the legal considerations to be taken into the legal considerations to be taken into account by the parties. It depends on so many factors that that the parties should always look at. Now, starting from the contracting process, we have in construction sector process that the parties should have, which is mainly failing under the offer phase. Then we have the acceptance phase. So these are the two main elements that the parties should consider while they are moving to the execution phase at the end. So if we go through the offer, for example, there should be always clear tendering process. There should be clear maintenance of records at the offering process. I have seen some projects where the employer has offered the contract and the contractor merely signed it because the project was quite big, but there was no details that could be technically taken into consideration. So the engineer got stuck in reviewing the contract because there were so many of aspects that were missed. And normally these aspects are confirmed in a tendering process or term sheet to be reviewed by both parties so they can negotiate and discuss it before they sign any clear agreement. We have seen that also there are some other agreements that should be always in compliance with the main tendering process and the construction agreement that to be signed at the last stage of the offer and acceptance, after the offer and acceptance phases. I know that as long as there is an offer and there is an acceptance, there is a contract, but in construction, we are talking about a very unique field that has to be taken care of. And therefore, once the agreement to be signed, once the acceptance is given, there has to be an agreement to be signed. And this agreement is also linked with other agreements, such as mainly subcontracts, because there are so many situations where the contractor is subcontracting some parts like supply, like, for example, relating to supply chain. We have the insurance, we have the designing, we have the construction, we have the labor, all these kind of activities that are mainly relating to the main agreement has to be considered while the parties are agreeing on the construction project. Moreover, I think there is also another aspect which is quite important to be considered and properly managed by the parties, and mainly it's the burden of the employee while choosing his contractors, the appointment of the qualified and experienced engineers. Because at the end of the day, if there is an arbitrator or a judge is reviewing the document, he will rely on the engineering part or on the engineering explanation, because how the arbitrator or the judge will retrieve the intention or understand the intention, it comes from the technical part also. So what I would say that the appointment of a qualified or experienced and experienced engineers is a very important aspect to be considered. There is also a very important thing, and I think the contractors would object always on it, which is the obtaining of solid securities, performance bonds. If you would like to have a reliable project or reliable vendor to build you for a project, or to prepare or manage a good project, you have to have good security clauses in the agreement to secure your right in completing the project. And I have seen, for example, lots of checks exchanged between the parties, and there was a breach by one of the parties, and the security check was bounced simply because this is not an enough security. The law today has granted the parties with further rights to seek further securities, such as declarations before the notary, which is subject to enforcement directly, without having, even if you signed, for example, an arbitration clause, and there was an issued declaration at the notary public, then you don't need to go to the arbitration. There is a wide shortcut where you can immediately enforce that issued instrument before the notary public and open an enforcement. So you don't need to deal with complexity of nullification or complexity of reciprocity principles on arbitration. You can always have this sort of document. You have sometimes guarantee of third parties. So I have come across recently a matter where one of the employers have appointed a construction company, and in the agreement it was stated clearly that if the company failed to do so, then the owners will pay from their pocket. They have to bear the liability. So this is a very good idea that could be added in the agreement, basically, where the limited liability company can be liquidated, but the owners will be liable even post liquidation. And I have come across lots of experience this year where we were defending some companies, and during the case we have advised them to go simply to liquidation, and the opponents lost their rights to seek their rights against the contractors. I'm not giving it as a bad example, but as a strong example where we have utilized the contract in our favor. So this is a very simple example that we have come across just recently. So these ideas, or these parts of negotiations that always should be taken into consideration in order to avoid the complexity of a dispute in future.
Thank you, Mr. Redha. Moving on to a practical concern, timelines and costs. Adarsh, what can parties do to ensure that construction arbitration in Oman remains effective, cost-effective and timely, especially in large-scale infrastructure projects?
Yeah, this is a very common problem across the region, not just Oman, but there are things in peculiarities in Oman which help in resolving concerns in relation to time and cost. So, first of all, we have a very impressive arbitration center. The Oman Arbitration Center is state of the art and has imbibed rules of all salient institutions across the world. So they have, retained their cutting edge lead in this aspect. But for parties who seek to get quick resolution, we need to bear in mind the fact that these are complex issues often, and which have to be ideally adjudicated by qualified personnel. Now, if you were litigating in the Omani courts, you would probably be able to get a judgment faster than a regular construction arbitration. But given the vagaries surrounding the appeal process and the Supreme Court process, it is often better to opt for arbitration where you have the procedural flexibility and the ability to have issues determined by technical and qualified professionals. So there it's slightly better. And oftentimes, even for ad hoc arbitrations, Omani parties prefer appointing technically proficient legal professionals who are capable of resolving the dispute. So, and we have seen this across all paradigms, whether it is arbitrations in English language or Arabic language. So the Omani parties are very sophisticated in that regard. As for the other practical steps that people can take, I think it's very important to stipulate the precise mode of dispute escalation and not convolute it too much. Where you have provisions where stipulating different tiers, you often end up creating issues of admissibility or issues which take too much time for it to reach the arbitration stage. So it's not just, making sure that the arbitration kicks off in time, but it is very important that you enable the pre-arbitration steps to be easy to follow and not obfuscating. So where you have expert determinations, especially in contracts, in some Oman contracts, it is a popular choice. Expert determination is a popular choice because oftentimes contractors do not want to engage in arbitrations against the big state-owned enterprises. So these steps are very helpful to clarify technical disputes. But where you have DABs or senior executive negotiations as mandatory steps, then it's always helpful to make sure that the DABs are in place and make sure that you assign the senior executives who are capable of resolving this dispute during these negotiations, as opposed to just having them just meet and exercise a tick box in the ultimate dispute escalation. So the other thing is when it comes to procedural efficiency, there are definitely many steps that parties have started taking. The traditional style of having memorials often end up expediting arbitrations. So you have experts being involved in the beginning, and that always ends up at least saving 3 or 4 months compared to the common law style, where the expert reports and fact witness statements follow several rounds of pleadings. So the other thing that Omani parties are now sophisticated about is document disclosure stages. So people now understand that there are targeted means of seeking documents, and most of them now agree on electronic document exchange platforms to reduce the costs. And other things from an Omani law principle, it is clear that the cost allocation principle follows most other jurisdiction. The loser pays costs principle is generally applied. So frivolous claims are discouraged. delaying tactics are strongly clamped upon, and eventually costs are apportioned based on all your conduct in the arbitration. We now have technology also supporting a lot of these, hearings. Earlier, I remember in Oman, we faced difficulties in getting the transcript equipment passed through the Omani customs. So we had stenographers in Oman, in Muscat, but without their equipment on the eve of the hearing. So, but now, of course, it's much easier because a lot of Omani parties prefer having virtual hearings where the stenographers can transcribe the hearing from remote locations. So that's also one way of saving costs because you don't have to fly them in and deal with the customs and so on and so forth. The other thing is the other thing is obviously we have already discussed briefly, but we have to proactively engage with stakeholders and make sure you are notifying your client claims and issuing your letters in a proactive manner. The Omani Arbitration Center is very impressive. The mediation rules that they have is cutting edge. They act on it very fast. They, if you intend to start a mediation, even after the commencement of arbitration, they're amenable to, running things in parallel or putting the arbitration on pause if both parties agree. So these are ways to, also save costs in case you feel that some issues can be resolved through mediation and some, and only the others can be taken, or if you think the entire thing can be resolved in one go, that's even better. So yeah. Thank you.
Thank you, Adarsh. Now, turning to a recent and important legal development, David, in light of the Supreme Court's decision allowing judicial review of a London-seated ICC arbitral award involving an Omani party, how does this expand the jurisdiction of Omani courts, and what concerns does it raise for parties contracting with Omani entities? To what extent does this expanded review power potentially undermine the finality of foreign-seated awards, and how should arbitration clauses now be structured to mitigate this risk?
Thank you, Roshanara. I'm conscious of the time as well, so I will do my best to deal with what is quite an interesting and quite a complex issue, albeit fairly briefly. In terms of what's going on here, everybody who practices in the international arbitration world will be familiar with the New York Convention on Recognition and Enforcement of Arbitral Awards. It's I've seen it described as the most successful international treaty ever. I don't have a way of measuring that, but it's certainly up there. It's in effect a treaty that countries that are signatories to it essentially say that they will permit the recognition and enforcement of foreign arbitral awards in their jurisdiction without the domestic courts of that country getting involved. In other words, it gives parties certainty that where they obtain an arbitral award against a party based or registered in a foreign jurisdiction, they have got a reasonable chance of getting that award enforced against them in their country of origin. And indeed, this is something that is reflected in Oman's own arbitration law. In fact, in Article 1 of the Omani arbitration law, makes clear that without prejudice to the provisions of applicable international treaties in Oman, this law, that is the Omani arbitration law, should apply to all arbitration between public or private legal persons, regardless of the nature of the legal relationship at issue, if the arbitration is conducted in Oman, or if it is an international commercial arbitration conducted abroad and the parties have agreed to it subject to this law. So, in other words, Oman's own domestic arbitration law acknowledges that it applies to Omani arbitrations themselves or to international arbitrations where the parties have expressly agreed that Omani law should apply. So fast forward to the decision of the Supreme Court in 2023. In this case, a dispute arose between an Omani engineering company called VJ Tanks and a Qatari subcontractor. It's a contract for the installation of a number of tanks at Hamad International Airport in Doha. The contract was itself governed by Qatari law, and the choice of it contained an arbitration clause. Any arbitration was to be seated in England and Wales and to be conducted under the ICC. So it's important to note that the arbitration was neither seated in Oman nor based on a contract subject or governed by Omani law. Cape East, the Qatari subcontractor, commenced proceedings against VJ for, as they say, wrongfully terminating the contract and invoking a number of performance guarantees. And there were various counterclaims that we perhaps don't need to go into the detail of now. But if a hearing was held in London before a sole arbitrator, and when that award was issued, it found in favour of Cape East on almost all matters, and VJ, the Omani entity, was ordered to pay a full $1.8 million that was claimed together with the costs of the arbitration. Now, VJ first applied to the Muscat Court of Appeal and sought to declare the award invalid, arguing that it raised a number of arguments, including that the arbitrator had exceeded the arbitration agreement between the parties, that they'd failed to apply a relevant contractual provision, and as is common in these challenges, that the arbitrator had failed to apply properly the principles of impartiality and/or due process. But the Muscat Court of Appeal refused to get involved. They took the view that on the basis that the award was an English award, subject to English law and relating to a project executed in Qatar, there was no basis for the courts of Oman to get involved. However, the Omani Supreme Court took a rather different view, and it overturned the previous ruling of the Muscat Court of Appeal and held that the Omani courts, in fact, did have jurisdiction to hear proceedings to annul the award, where those proceedings had been instigated by an Omani entity in respect of an arbitral award that had been issued against them. And crucially, that it didn't matter that the arbitration was international, subject to a foreign seat and/or foreign governing law. It was enough that that VJ, the defendant, was an Omani entity, and as a result, the Omani courts had jurisdiction to determine the matter. So, although the court didn't actually address the substantive issues of the challenge in that case, it did refer the dispute back to the Muscat Court of Appeal for further determination, essentially concluding that it did have jurisdiction to hear the dispute. And recalling what was said about both Oman's arbitration law and the New York Convention, it's quite clear that this is something of an incursion into what were well-established principles of international arbitration. Omani courts getting involved in a dispute that is neither seated in Oman nor governed by Omani law is clearly not something that is contemplated by the New York Convention, or indeed by Article 1 of Oman's arbitration law itself, which, as you'll recall, required either the dispute to be an Omani dispute or one where the parties have agreed that the arbitration should be seated in Oman. So there is a clear inconsistency between Oman's own arbitration law text and the approach that was taken by the Supreme Court, which obviously raises concern not only of greater judicial activism, if you like, in this regard, but also of inconsistency of approach between courts that might adopt an approach that is more consistent with the understood principles of international arbitration and those that don't. I mean, in this regard, Oman is far from the first country to grapple with the conflicting desires to promote itself as a global arbitration and commercial hub, but also to protect its own national entities and to be blunt, to prevent an outflow of capital from the country. It's a contradiction, a contrast that has been grappled with by a great many countries. But it is clear that this sort of lawmaking is not the sort of thing that commercial parties respond well to, either in the arbitration context itself or indeed in a broader commercial context. Because if there is a risk that in contracting with an Omani company instead of one based in another jurisdiction, there is a risk that the dispute could get dragged into the Omani courts, notwithstanding that the parties have agreed that it would be governed by an entirely different legal system. It's clearly something that is going to factor into the risks of doing business in that regard. And it also raises the unedifying prospect of potentially inconsistent court proceedings to try to enforce awards in multiple jurisdictions, which again is exactly the sort of thing the New York Convention was designed to avoid. So what can parties do about this to protect themselves? Well, the short answer is in circumstances where you are doing business with an entity that is based in Oman, it is going to be a risk for the foreseeable future. There are things that one could put in one's arbitration agreement, for example. One could perhaps seek to expressly waive any right to challenge an award in a court outside of the seat. One could try to make clear that the dispute has no connection with Oman in the arbitration agreement. Make clear that make sure that the jurisdiction clause is in exclusive terms, thereby expressly stating that other courts, once the relevant arbitral tribunal has been seized of jurisdiction, other courts can't get involved. And one could, for example, have a contract clause that says something like the arbitral award should be final and binding, and any application for either annulment or review may only be made to the court of the seat, and the parties waive irrevocably any right to challenge that award, including courts of their own country. And that might get you somewhere, but let's be absolutely clear. The crucial sort of, if you like, nub of what the Omani courts have done is that they are effectively carving out a right to get involved on grounds of ultimately public policy, the dreaded exception that has been invoked by courts around the world to refuse enforcement of various awards. And so in circumstances where, and I've seen in the past, although the Omani courts are prepared to consider forms of alternative dispute resolution, they have equally been prepared to strike down clauses that, for example, might bind the parties to use some form of alternative determination. They are prepared to get involved. They are prepared to strike down dispute resolution clauses. And so I don't think one can guarantee that the clause will necessarily be upheld in the Omani courts. So for the time being, until such time as any action is taken on this, I think parties contracting in Oman or with Omani companies, must be aware that there is a chance that the dispute could be prolonged even if you get an award in your favor because of this decision of the Supreme Court and the potential for it to find its way into the Omani domestic courts. Thank you.
Thank you, David. Moving on to the next question. Nikolay, in your experience, what are the most common causes of claims in Omani construction projects, and how can employers and contractors proactively minimize these risks?
Okay, thank you. A great question. So, based on our experience in construction disputes in the GCC and Oman precisely, there is a number of key issues, but I would say something. All the things are really interconnected, so it's really hard to define the precise list of these causes. But anyway, so I would name such things as delays in project implementation, variations, and determination of actually performed works when it's not clear for both parties, failure to achieve the design capacity of the project, equipment supply disruptions, and budget overrun. So let's start from the first one. So delays. Employer and contractor actions and other factors such as force majeures, we all remember, for example, COVID-19, climate factors, which is really relevant to Oman, government, political related causes, all the things they affect the timeline of the project. For example, some instance from my experience, it was an ammonia plant project in Oman. So the employer has engaged a well-known EPC contractor, and the project was prone to delays, and the EPC contractor submitted its time costs seeking extension of time, like equal to 300 days, I guess. Extension of time, and the claim equal to 20% of contractor's lump sum. And delays have been caused by such things as change in law events, material supplies, disruptions, vendors representative supervision problems, equipment defects, commissioning permits, and many others. For example, in other project, also in Oman or an oil and gas project, EPC contractor filed EOT claims because of tropical sandstorms. Maybe someone remember Cyclone Mikunu in 2018 in Oman. So it was the case actually. And basically there is a myriad of problems causing delays, like equipment and material supplies problems, design and engineering problems, geological problems, etc., etc., etc. So the second thing I would like to mention here is variations and determination of actually performed work. So here is an example. In oil field projects, so the employer engaged a well-known international EPC contractor. So the EPC filed a case in the arbitration, and a big part of these claims, which were like 200 million, I would say, United States dollars, were related to variations because some requests for variations were rejected unfairly in opinion of according to the EPC. And it was early complicated for the EPC to justify and substantiate these variations. So main challenges here are in variations, design incompleteness and incorrectness for sometimes enforcing geological conditions, ambiguous contractual definitions and variations, lack of prior written approval, failure to assess time and cost impacts before work commencement, poor documentation. Speaking of when it comes to we cannot when in moments when we cannot determine a volume of actually performed works, here are some such problems as lack of clear and proper evidence, disagreements over quality issues, measurement and quantification of works are really problematic. And there are many more problems besides delays and variations, like for example failure to achieve the design capacity of the project. So in my experience, for example, an employer engaged a very well-known equipment supplier, world-class equipment supplier. But in the end of the project, he just found himself that his project doesn't work correctly. So the project, the terminal can't do what it needs to do. And and where is the problem? So how we can define it? Maybe it's because of equipment, maybe it's because of some operational things, maybe it's because of raw materials or energy sources, who knows. And it's very complicated to justify, to substantiate your position here. It's and everywhere we see such problems. Equipment supply disruptions, for example, it may be connected to equipment quality, delays in equipment, surely. They need to rectify equipment to I don't know, to work it better, or for example, you have some limitations in equipment work and so on. Budget overruns, surely, when it comes to construction, it is so well spread that we have some budget overruns, so you can't forecast how much it will cost in the beginning of the project. And and many times both parties, well, all parties, employers, EPCs, designers, all can find themselves with some funds shortage, and it's absolutely very, very common things. To summarize, I would think so. Okay, surely, if we have some risks and we have some problems and causes leading to these problems, surely we have some mitigation. So to summarize, I would say the main recommendations here are comprehensive contract. So contract is our holy book. So we need to take into account every tiny detail, all the procedures, all the responsibilities, all the, I don't know, payment orders, penalties, and so on, and so on. You know, we need to do that, and contract should be very, very, very comprehensive. The second thing would be here, the more detailed contract is, the better, especially in terms of technical issues like scope, like schedule, master program, budget, bill of quantities. You need to break it down. You need to make it really, really in depth in order to have an ability to control it, in order to have an ability to maintain it, and to verify it, and so on and so on. The next thing would be records. So we need to record everything. So we all know that, like, construction is like a marriage. So when you get into this, you think that you are happy, you are, satisfied with all you have, but who knows what will be, like, in 5 years, in 10 years, or something like that. No, like, no partners know that. And it's just like, and in construction, we also have this. And when we draft a contract, we should remember that everything may happen. So we need to record everything, like every email, every letter, every schedule, every protocol, and so on. We need to record it, and we need to establish rules for recording. So we need to establish it in the contract. So we need to record all our activities within construction. And also about this clear and transparent reporting and monitoring structure. So we need to establish and ensure it in our contract. And also just like probably 5 seconds about Omani specific best practices. So speaking of Oman, I would recommend such things as force majeure tailoring. So explicitly lists sandstorms, because we know it's a very common thing in Oman. Government permit delays. So there are many problems with governments, with approvals in Oman. We know that it's, we have some bureaucracy problems here. Water scarcity, for example. Also, likewise, in other GCC and Middle East problems, you need to consider all Islamic holidays, all day offs, and so on. The next thing would be cultural alignment. So Arabic, English bilingual contracts with defined, government language. I think it's very, very, important here. Sharia compliant financing terms, if Islamic funding is involved. We all know it's a very sensitive thing, and we need to consider it. And proactive tip would be here, probably contact contract workshops with Omani legal counsel presiding to address, we need to consult. It's absolutely good, and surely they will give you a very comprehensive piece of advice to draft a good contract. So here is the conclusion. A well-drafted contract won't eliminate all disputes, but it will create pathways to resolution by respecting Oman's unique, let's say, legal and commercial environment and landscape. Thank you so much.
Thank you, Nikolay. Now, looking at the bigger picture, Mr. Redha, what, according to you, are the main legal and practical challenges currently facing Oman's construction sector that are leading to increase in disputes or complicating the dispute resolution process, rather?
Okay. Basically, when you talk about a dispute, it's a dispute, which means that there are lots of challenges between the parties are going on. And these challenges started prior to the filing of the dispute and during the dispute, basically. It could be extended always to the enforcement process also. Now, if we talk about the dispute, basically, or look at the challenges, basically, we have the first of all the contracts, basically. it's the biggest challenge for all the parties, especially once they are signed, they are performed under the duty of the parties, and suddenly the challenge, the conflict pop up. So we have to go through the agreement or the contracts. The contracts are the main reason of a dispute, and it could be also the main reason of any settlement. So the challenge is whenever the clauses are based on principles that are falling out of the experience of the parties, I would say, where the parties have adopted some parts that could not be enforced in our jurisdiction, or that could be in conflict with the laws that could regulate such agreements. So these are one of the challenges that need to be considered always by the parties, and it always helps, obviously, the parties to reduce the disputes, or in case if it is drafted in the worst manner, I think it will be a good reason for the increase of the disputes between the parties. Now, the main thing on these contracts, we have the interpretation of the intentions. I think the intentions in construction disputes are very fundamental. Explaining or interpreting the documents before the arbitrator or the tribunal or even the court's bench are very important, because they are based on legal facts and technical facts. In case if there are some basically in case if there are some challenges to understand these information or these instruments or the technical part of the dispute, it can always escalate the relationship to a worst case scenario. After that, I think the formalities, basically, the formalities that are agreed in the contract play a very fundamental role in increasing the disputes, especially for those clauses that always could fail under the discretion power of the court to be amended. Taken into consideration that the court, even if the parties have signed the contract in a particular manner, the court can redefine the intention, or let's say redesign the clause in different way based on an independent interpretation and findings. So these could this manner or this way could always take us to another sort of dispute and discussion at the tribunal or the court. And I guess, I think our colleagues on the panel could correct me, this is always something that is not really existing under the common law, but in the civil law system, the judge sometimes retains this right in a way to correct the situation, and this situation should be in compliance with the codified text of the law. Determination of the jurisdiction is something also that always play a very important role, because don't forget that we have two bad scenarios that we have, especially looking at the arbitration. We have the nullification process, and then we have the enforcement process. If we do handle the dispute in a jurisdiction that could not meet with the public policy of Oman, then we can face a nullification situation, and therefore the determination of the jurisdiction was not a proper option that the parties have chosen from the beginning. The challenges are, in the arbitration, especially cost of arbitration. I have come across that there were some special vehicle companies, special purpose companies were established for a purpose, and because they were not paid on time, they suffered, and they reached to a level where even they were looking for a funding party on the arbitration disputes. And this is something that we can reach out, where the party can get or can be stuck whether to file a case based on a loan and then lose the case, or the case take more than anticipated and the loan is not paid, which is another suffer for the party, or they go through the court, where also there are another sort of challenges that they can face, that the party can face. Taken into consideration, there were recently royal orders issued by His Majesty rescheduling or restructuring all the court fees. In the past, in the commercial disputes, the cost of the court was 2% of the total claim. Now it is not more than 500 riyals, and many cases are starting from 10 riyals. So this decision have solved some obstacles in order to have a proper case from the beginning with less burden. Another thing which is also becoming a very boiling item, which is the nullification process of the arbitral award. The nullification, as you know, is a fundamental part that was covered by the Oman arbitration law, and there are 9 exclusive situations that could allow the losing party to have or to seek the nullification. I would say that losing party will take it as a strength point to delay the payment and extend the dispute from the foreign jurisdiction or from the ad hoc arbitration or even from the organizational arbitration to the court, which is a reason to extend the dispute again. And we have also the reciprocity, which is also a very important aspect that we need to look at it. To be frank, it also relates, it is always based on the collaboration of the lawyers, basically, to exchange the information of reciprocity. Because as a Omani lawyer, I would say, okay, I'm relying on the other party's reciprocity in order to have an enforcement of the award here. And the other lawyer could also have the same idea, where they will rely on the Omani lawyer to confirm whether this foreign award could be enforced or could be applied here in Oman, and there is a chance of having an extension of the dispute once a judgment or foreign judgment is issued. The other reason, which also could always, create a headache for the parties, is the conflicts between the contractor and the engineer. I have come across of a very bad situation where the employer filed a case against both of the contractor and the engineer. Both of them, had defended themselves to the bone, and at the end of the dispute, both of them were jointly liable. And this was a big issue when we have gone to the enforcement. Everyone was trying to justify, or everyone was trying to trying to throw the liability on the other, where joint liability is also a matter that needs always to be considered as a strategy. So for example, if the defaulting party was the contractor, why should we involve the engineer? For example, the engineer is not a defaulting party in the dispute, but we have come across a situation where the engineer was involved, and based on the findings of the court, he was also taken as a liable party. Maintenance of the documents. I have a current situation right now where we are asking for the main contract, but our client doesn't have the main contract, and we are now relying on the subcontract. That's one of the challenges. So maintenance of the documents is a very important thing. because it could be a reason of increasing the dispute. While if you have a full setup of document, it might help you to solve the dispute from the beginning. Finally, I would say that the enforcement process is is one of the most common challenges. Enforcement process is not about enforcement of a foreign award or enforcement of an arbitral award. It's the enforcement at the court, opening an enforcement file, trying to find the assets, trying to track the cash of the losing party, of the liable party. You have also a challenge of issuing an arresting memos, because even an arresting memo could pressure the company, but it cannot solve the lack of liquidity of our clients, basically. So these are main challenges that we are finding, because these processes are part of the either of the substantial part or of the formal part of the dispute, and uh, one or all of them could always extend the dispute and extend the conflicts between the parties mainly.
Thank you, Mr. Rida. Now, let's discuss an issue that often becomes contentious when disputes arise, the arbitration clause itself. Adarsh, what are some common pitfalls you have observed in arbitration clauses within construction contracts in Oman, and how can they be avoided?
Yeah, thank you, Roshanara. So there are a lot of there are problems that arise out of the arbitration clauses in some of the construction projects in Oman, and I don't think we can isolate this as an Oman problem. Although there are some issues surrounding the correct appointing authority for in case there's a dispute about the sole arbitrator to be appointed, or if the respondent does not nominate their arbitrator. There are sometimes this disagreement on whether the administrative court possesses the authority or the local, civil court of first instance. And sometimes there are issues that are eventually determined at the setting aside stage. So let's look at other problems. I mean, the Oman Arbitration Center has a great model clause. It recommends a little bit extra in my opinion, but it's safer to be a little more descriptive compared to the ICC model clause or the SIAC model clause. So I still recommend the more descriptive Oman commercial arbitration clause, arbitration center clause, because it has all the classic tick boxes that I would recommend at the time of negotiating the contract. So the most important, according to me, is to have coverage on what can be arbitrable. And these days, stipulating that any dispute arising out of or in connection with the contract is considered to be good enough. And as for the seat, it's really important to specify the seat or place of the arbitration. And that really will ensure that the concerned civil court would have supervisory jurisdiction over any issues that may arise before or after the arbitration. So in many circumstances, we recommend that the parties also stipulate the number of arbitrators. So it's even though it's not a legal requirement, um, it's always helpful to set out the number of arbitrators in advance, because you can avoid any issues later during constitution of the tribunal, and that will also enable you to avoid going to court for any clarification. So the other thing that we often recommend to contractors especially is to avoid too many tiers. I mean, We have seen that some contractors, some employers insist on tiered clauses where issues are often categorized as issues of admissibility, if especially if there is mandatory language. But I think in many cases, especially in Oman, having the option to resolve disputes through negotiations or mediation uh, is often helpful for the contractor to um, see if they can attempt a resolution. Uh, yeah, and I think one thing that is that I've seen very helpful in Oman is um, the coverage aspect does not often come into play. In many cases where issues on what the tribunal's jurisdiction covers, there is sympathy to create a bifurcation, especially when you feel that you have a strong case on jurisdiction. So in my experience, I've seen Omani tribunals not being sympathetic to the idea of bifurcating the arbitration proceedings just to cater to the jurisdiction objection, which is very helpful to expedite the arbitration if you are a claimant. But if you're a respondent, I suppose you would be concerned about having to expend all the costs, um, especially when it comes to arbitration and the jurisdiction. So there are many state enterprises which as a matter of rule insist on um, attempting nullification of the award or setting aside of the award. For several government related contracts, we know that the parties are not at risk of the money going away. The enforceability is greatly enhanced if you have the Muscat court as the seat, because you know that they will be able to enforce the payment in case you're successful. Of course, there's a large caveat in relation to public policy considerations, which often leads to unenforceability. And I suppose we have already discussed this in great detail. The other thing is there are still some classic issues on public policy which have often, created problems in the past for contractors, whether there's adequate Omani legal representation in the arbitration, whether each page of the award was signed, whether uh, whether all three arbitrators had equal opportunity to discuss and deliberate upon the findings. They have previously, these issues have resulted in long drawn arbitration proceedings to be set aside, awards to be set aside, which has been disappointing to parties who have, prevailed in the arbitration. But here it's really important to understand the legal culture, and wherever necessary, it's important to make sure that all of these considerations are met with, and so that you do not have any public policy arguments that may lead to such unforeseen consequences.
Thank you, Adarsh. Looking ahead, David, what key developments or reforms would you like to see in Oman to enhance its position as an arbitration-friendly jurisdiction while ensuring legal certainty for foreign parties?
Many, many thanks. I think I've already touched on this to some extent in my previous answer, that I see personally Oman as at a little bit of a crossroads in this respect, and it's ultimately there's a bit of a decision to be made as to whether it's going to jump towards greater commercial openness and transparency to promote an arbitration-friendly culture, or whether it is going to, I use the term possibly inaccurate, but regress back to a slightly more protectionist approach. Adarsh has done an excellent job of identifying a number of the sort of the problems on a day-to-day basis that parties encounter in their arbitrations in Oman. It's worth, I think, just acknowledging at the same time that as a venue for international arbitration and for business generally, Oman has a lot of positive. It has a lot of attributes that are to its advantage. It's a open, stable jurisdiction in what is, let's face it, an increasingly challenging part of the world, with a great number of infrastructure projects being built, both inside Oman and outside Oman by skilled Omani contractors, and in that regard, all of the building blocks are there for it to operate as a jurisdiction that is receptive to international arbitration. But obviously, as with many other jurisdictions around the world, there are wrinkles to be ironed out. And one of from my own experience, one of my perceptions is that there was a little bit of COVID came at just the wrong time for Oman, because it was on a very clear track towards opening up its international arbitration market. A good number of practitioners were spending increasing amount of time in Oman, and I think just the necessity of sort of being confined to barracks, as it were, during COVID, meant that a lot of practitioners either didn't visit Oman as often as they did less work there, or in some foreign lawyers' cases actually departed from Oman. And I think that had a bit of an effect that it's taken a few years to recover from. But I think there is, to bring the conversation back to the start, the initiative, the Vision 2040 initiative that's been announced, the sort of the proposed economic liberalization ties in, I think, quite neatly with where Oman wants to go with this. And one can see legal predictability, and particularly in the context of international arbitration, as being a key plank of that strategy, if I understand it correctly. And I think, given the question was asked slightly in the aspirational, and then I was able to identify what I would perhaps like to see rather than what is going to happen. It's always dangerous to make predictions. What would benefit Oman at this point, I think, is perhaps three key aspects. The first is I think to deal with the approach, the interventionist approach that has been taken recently by domestic courts to restate Oman's commitment to the New York Convention, to make clear to domestic courts and local judges that there is if not a carve out, there is a margin of appreciation to be given to arbitration matters, that they are ultimately not to trespass upon, to explain, to reaffirm the importance of the exclusive supervisory jurisdiction of the seat of the arbitration, wherever that is, whether it's in Oman or whether it's elsewhere, and perhaps to clarify in the Oman arbitration law once again that the Omani court's jurisdiction is either excluded or is very limited in circumstances where the award is a foreign-seated one. We've talked quite a bit about public policy. I think it's important to restate the commitment in the New York Convention that public policy exceptions apply at the enforcement stage, rather than to allow a sort of premature supervisory jurisdiction over arbitral awards, which I think is unhelpful and risks complicating and adding to the time and expense of proceedings quite extensively. From an institutional perspective, we've talked a bit about the Oman Arbitration Centre, which is an excellent initiative, and hopefully as time goes on, the expertise and the experience there will increase. But it's perhaps sensible to make sure that the Oman Arbitration Centre is able to itself put forward clear modern rules, reaffirm its principle of institutional neutrality, even where there are Omani parties involved, make sure that they're taking soundings from high caliber practitioners from both inside Oman and the GCC and around the world, just as other jurisdictions have done when they've built their own arbitration centres. And perhaps finally, where the courts are dealing with arbitration business, to make sure that those judgments are published, and published perhaps not only in Arabic but also in the English language, so that practitioners around the world who are doing business either in Oman or with Omani companies or Omani entities have better access to jurisprudence from Oman. So none of these things are particularly onerous. It's a subtle shift rather than a wholesale change in culture. But hopefully in the years to come we'll see that sort of recommitment to legal certainty and to transparency as part of the broader economic strategy that Oman seems to have outlined. Thank you.
Thank you, David. That was a great perspective. Let's wrap up the segment with a question about proving costs. Nikolay, what documentation or methods provide the most persuasive evidence in proving quantum for prolongation costs and variation claims?
Yeah, a great question. So in Omani construction disputes, providing quantum, especially for prolongation costs and variations, requires a combination of, let's say, contemporaneous documentation, methodologically sound analysis. So based on my experience, here are the most persuasive types of evidence and approaches. So let's start with key documentation for prolongation costs. So to provide additional costs to project delays, the following records would be beneficial. Protocols of performed works, daily site reports, progress photos, such because they show actual and planned progress and disruptions. They can show, for example, harsh Oman's climate, like sandstorms, extreme heat, and so on. The next sort of documentation would be updated construction progress. I think, sorry, not programs, yeah. I think that it is one of the most important tools in hands of the delay experts. So construction program, master program, and schedules in electronic format of Primavera PC or Microsoft Project would be really beneficial and would be so useful for a delay expert. They can demonstrate critical path delay. They include much information about resources, about relations between activities, and so on and so on and so on. And they allow you to conduct many kinds of analysis, like time impact, as plan as builds, collapse, make different scenarios, and so on and so on. The next thing I would highlight here is accounting documentation, so cost ledgers, cost reports, and so on, because they can provide breakdown of extended, site overheads, for example. They can prove additional financial costs, bank statements showing higher interests due to delays, for example. And the last but not the least, correspondence, surely. So all the emails, all the minutes of meetings, notices, and so on. And they just, we have signatures, we have the information, these documents. They show timely notification under the contract. So they can prove much information and much facts and arguments. Speaking of best methods for prolongation costs, I would say it depends on a contract, because we can have different mechanisms how to calculate it. So the most populated would be, in my opinion, is just when we have some kind of a prolongation penalty, prolongation cost rate, or something like that, and we just multiply number of delay days. We number it by this rate or something like that, and we use just standard methods like time impact as plan as build, collapse as build, old retrospective and so on in order to calculate the details. Then we just multiply it. But we can try and have different other methods to calculate prolongation costs, such as Ashley formula, time-dependent cost allocation, Hudson formula, like an alternative to Ashley, measured mile, and many others. So in Omani context, I would say that we need to try to stick to well-known methodology. This is the case. So this is really liked and respected in Omani arbitrations when you rely on well-known and recognized methodologies in politics, policies and standards. They they respect it and they can believe and trust you. Speaking of variation claims, I think it's very obvious. So we need to have signed variation orders, VOs. We need to have priced bill of quantities, bill of queues, or any other reflection of lodges, with a number of words, with a number of costs, and so on. The worksheets will be really beneficial here, and also time and matter records, surely here. Speaking of Oman, I think that we need to remember this thing. So first of all, we need to ensure that all the documents are properly notarized and translated into Arabic and into English and so on, because this is bureaucracy. We all know that, so we need to do that. Probably we need to, there are some tribunal preferences, Oman seated arbitrations favor dated photos, videos of a generic report. So when they see that, some photos or video, they have dates, oh, okay, I believe you, that's all right. So yeah, that's true. They also like independent third-party reports, some for example, if we speak about sandstorms or something like that, if they see a weather agency report, so they can agree with that. Okay, so I see they just prove it. They well known, they are trusted, independent. Okay, and probably the last thing I would mention here is just we need to avoid global claims. So Oman tribunals often reject total cost claims when someone just wanted to have it all, but it's not like that. It's construction. So there is, I would say that in any construction project there are no white and black, so there is something that is always gray. So there is a myriad of actions, correct and incorrect, and surely some of this action lead to some problems which then are just are considered in arbitration. So in this regard, you need to meticulously calculate and analyze what you have. You don't need to claim everything that you have. No, you need to analyze it. You need to analyze it in a very diligent way, and then arbitration, they will look at this and they will okay, I see, so that's some work done here, so, and yeah, I can trust it. So I think it's something like that. Thank you so much.
Thank you, Nikolay. Unfortunately, we won't be able to take any live audience questions today due to time constraints. Please write to us if you have any questions. Thank you to all our esteemed panelists for sharing such valuable insights today. On behalf of MRP Advisory, thank you all for joining us. We hope you found the session useful and thought-provoking. Have a great day ahead. Thank you. Bye.
Thank you so
everyone.
much.
Thank
Have a nice
you.
day.
Thank you very much. Thank you.